Welcome to Scottish Murders. I'm your host Dawn, and this is part 3 of the Kay Wyllie and Nancy Nichol case. Part 2 covered the murder trial where 19-year-old Andrew Cameron was accused of murdering both Kay and Nancy, and I ended that episode just as the jury were going out to deliberate. I'm going to pick back up with the jury delivering their verdict, so let's get started. Guilty. The jury of 4 women and 11 men found Andrew Cameron guilty of the murders of 19-year-old Kay Wyllie and 18-year-old Nancy Nichol, deciding to accept that Andrew's statements made to the police were true and rejecting Andrew's claim that the statements had been made under police duress. Judge Lord Ross sentenced Andrew Cameron to 2 life imprisonment sentences and recommended he serve at least 20 years, initially in a young offenders institution until he was 21, before being eligible for parole. Andrew began to cry as his sentence was read out, before he was taken away to start his sentence. However, just before he left the dock, he dramatically shouted, "The CID all lied." This murder trial had been full of drama right to the end, but the trial was definitely not the end of the drama. It continued right outside the courtroom, with an article in the Daily Record on the 19th of September 1985 being titled, "Fury as Double Killer Gets 20 Years." So you might be wondering why there was fury about Andrew Cameron receiving 20 years for murdering Kay and Nancy, but the article was a bit misleading. That's not what people, including Nancy's parents, William and Agnes, and Kilmarnock Labour MP, William McKelvey, were furious about. They were furious that Nancy had been murdered at all, with her parents saying, "Our girl didn't have to die." And they wanted answers to their questions which Nancy's grief-stricken mum, Agnes, put to reporters outside the courtroom, saying, "If Cameron had been arrested, he wouldn't have been able to murder again, and my Nancy would still be on this earth. I want to know why the Crown Office didn't make the decision to charge him. My lassie died because they dragged their heels. He should have been arrested or even watched 24 hours a day so he couldn't kill someone else." While they sat back deliberating, Cameron killed again. Nancy's dad, William, also said to reporters, "My wife's been in an awful state since Nancy was murdered. She'll never be right again because our daughter was taken from us. And yet Cameron will eventually be out on the streets again. He should be put away for good. All we have left to remind us of our daughter are photographs and some ornaments she bought for us. We want an inquiry to find out who was responsible for allowing this killer to roam the streets." The MP, William McKelvey, was just as scathing when it came to his criticism of the Crown regarding their alleged inordinate delay in prosecuting Andrew Cameron, as in his view there was enough evidence for the arrest and prosecution of him for the murder of Kay Wyllie long before the murder of Nancy Nichol, saying that the lack of willingness to take the decision to arrest Cameron borders on negligence. So Nancy's parents and MP William McKelvey wanted to know, why did it take the murder of another girl before Andrew Cameron was arrested? And why did the Crown sit on the case against Andrew Cameron for months without coming to any decision on whether to arrest him? And they were expecting the answers soon. So let's have a look at what occurred after Kay Wyllie was murdered and why Andrew Cameron was able to go on to murder Nancy Nichol. Well, we know that Kay was murdered on the 4th of July 1984, and apparently, according to the same Daily Record article, Andrew Cameron had become police's #1 suspect days after this. We also know that Andrew's fingerprint was found inside Kay's abandoned white Mini, but that's really all police had. And we know that Andrew had been questioned repeatedly by police, both after Kay and Nancy's murder. Now, apparently 5 months after Kay's murder, police believed they had a case against Andrew, a very slim one though. But Andrew was not arrested or charged, as police feared that there just wasn't enough evidence, and if they arrested Andrew, then they ran the risk of the Crown releasing him due to the lack of evidence. And so the police sent a report to the Crown for them to make a decision on whether there was enough evidence to arrest Andrew or not. However, that is where the report sat for a further 9 months, without the Crown making a decision. Senior police officers apparently approached the Procurator Fiscal every month to ask if a decision had been made yet, and each time they were told that the case against Andrew Cameron was still under Crown Office consideration. And then on the 2nd of May 1985, Nancy Nichol went missing and was later found murdered. So I can kind of see both sides here. If I was the family member of a loved one who had been murdered and that person had already killed someone, I would be annoyed that they had been allowed to kill again. However, I also know that police need enough evidence to arrest and charge someone, and ultimately that decision is down to the Crown Office and Procurator Fiscal Service. So I do feel it a bit unfair that the blame seems to be with the police here. But the police remained tight-lipped about the matter, leaving it to the Crown Office to defend their actions. Specifically, the Lord Advocate at the time, Lord Cameron, and he was just as scathing in reply in a letter to William McKelvey that he made public, in which he asked William McKelvey to accept that there was no justification in the statements he had made regarding there being an inordinate delay in Andrew Cameron being prosecuted, saying that, "I do not know on what basis you consider yourself to be justified in reaching such a view. Nothing could be further from the truth." And he was asking him to withdraw these statements. The letter then went on to explain the Crown's position and why no arrest warrant had been issued for Andrew Cameron before Nancy Nichol was murdered. I'm not going to read out the full letter, it's quite long, but here's the main points. Lord Cameron explained that police had reported the case to the Procurator Fiscal from the outset, and by December 1984, all available information, including the limited material hinting at Andrew Cameron's involvement, had already been passed to the Crown Office. Crown Counsel then ordered further inquiries, but there was wholly insufficient evidence to justify any arrest, and the additional investigations that were carried out produced nothing that could support the criminal proceedings. According to Lord Cameron, no new evidence emerged until after the disappearance and murder of Nancy Nichol. It was during questioning about Nancy Nichol's murder that Andrew Cameron unexpectedly confessed to murdering Kay Wyllie, and only then, combined with the earlier information, was there finally enough evidence to prosecute him. Lord Cameron went on to reinforce this point by quoting the murder trial judge's direction to the jury, which was if Andrew Cameron's police statements were excluded as unfairly obtained, the jury would have to acquit, as no other evidence was strong enough to support the charge. Lord Cameron concluded his letter to William McKelvey by saying, "I cannot make it plainer to you that without the evidence of these statements any earlier, prosecution of Andrew Cameron must have resulted in this acquittal," adding that it would have been wholly wrong to lay a charge of murder when there was, and was known to be, insufficient evidence to obtain a conviction. Okay, so that all sounds quite reasonable. There just wasn't enough evidence to charge Andrew Cameron for Kay Wyllie's murder, until sadly Nancy Nichol had been murdered. Bit of a hard pill to swallow. But did William McKelvey accept this explanation and retract his statements? Of course he didn't. He doubled down by saying in an article in The Scotsman on the 27th of September that "My criticisms may have been harsh, but you cannot say they were unfounded. There was an inordinate delay. That is not just my view, but is the view of the parents of Nancy Nichol. That view was also shared by police officers." Going on to say, "In no way am I repentant about my inquiries or having expressed my feelings." Okay, so both sides feel that they are right in their views and they're not backing down. So where will this go next? Well, it goes nowhere and is not mentioned again in newspapers, despite there being no resolution or accountability, as within days of the murder trial ending, another dramatic story, again related to Andrew Cameron, hit the headlines, with an article in the Daily Record on the 27th of September being headed, "Riddle of New Witness." So apparently, 5 new witnesses had come forward and made statements to Andrew Cameron's solicitor, Joe Beltrami, about the Kay Wyllie murder case. One witness was Ruby Steed, who had got in contact with Andrew Cameron's mum on the 10th day of the trial, and Andrew's mum had in turn put Ruby in touch with Andrew's solicitor, Joe Beltrami, and Ruby gave him her statement, which, by the way, she had also given to detectives at the time of Kay Wyllie's murder. Another witness was Ruby's husband, Hugh, who had been with Ruby on a night out when they saw Kay's white Mini, but Hugh was not happy that Ruby had got them involved at all, and I'll tell you why soon. The other 3 witnesses had also come forward with their evidence after Andrew Cameron had been convicted and following a radio appeal. You might be wondering why Ruby Steed wasn't called to the stand at the murder trial if she came forward with her evidence before the trial ended. Well, that was because apparently the names of witnesses to appear at the trial to give evidence must be given 3 days before the trial actually starts. And while Joe Beltrami did attempt to have Ruby Steed also appear at the trial to give this new evidence, this had been denied. So, after the trial, Andrew Cameron's solicitor, Joe Beltrami, and his advocate, Nicholas Fairbairn, began assessing Ruby and Hugh Steed's evidence, as well as the 3 other witnesses who had come forward after the trial, but who hadn't been named yet, to see if their evidence was strong enough to be included in their appeal of Andrew Cameron's conviction, which they had planned to lodge anyway. As it turns out, the new evidence from the 5 new witnesses was strong enough, in their opinion, to actually clear Andrew Cameron of murdering Kay Wyllie, and so appeal papers were lodged, asking the appeal court to consider evidence from 5 new witnesses in regards to Kay Wyllie's case. So before I tell you what this new evidence was, let me tell you why Hugh was not happy that his wife had got him involved in Kay Wyllie's case. It was because he himself had previously been in prison for 8 years after being found guilty of culpable homicide in 1960, and he knew this would be dragged back up if his name was put forward, which of course it was. According to an article in the Daily Record on the 23rd of September 1985, Hugh, who was 20 in 1960, and 4 others were found guilty for the killing of 27-year-old William Leckie, who collapsed and died on a bus after he had been stabbed outside a hotel in Ayrshire. When Hugh was asked for a statement by the Daily Record reporter, he said, "I am not prepared to discuss my background. My wife acted in a pure, spirited way, and her statement to the police has nothing to do with me." So back to the new evidence. While the full account would come out later, the basics were that Ruby Steed was claiming, and her husband Hugh was backing her up, that she had seen Kay Wyllie driving in a white Mini in Prestwick with a man that was not Andrew Cameron in the passenger seat in the vital hours before her death. The precise time of Kay Wyllie's murder had never been determined. At the murder trial, 2 other witnesses had come to the stand to say that at this same time as Ruby claims to have seen Kay driving her car in Prestwick, they claimed to have seen Kay in Dundonald, about a 20-minute drive away. At the time Ruby Steed's evidence was disclosed, Joe Beltrami refused to name the other witnesses that had come forward with evidence about Kay Wyllie's case after the trial. It was expected that the appeal would be heard in either December 1985 or January 1986, where the new evidence would be considered, and it would be decided if there was in fact enough evidence for this appeal to go to the next stage, to determine if a miscarriage of justice had taken place. However, this reviewing of new evidence did not actually take place until the 2nd of May 1986, over 7 months later. But we didn't find out a whole lot more at this hearing. Only that Nicholas Fairbairn, Andrew Cameron's advocate, put to the 3 appeal judges that he believed Andrew's conviction was a miscarriage of justice, that the confession he was alleged to have made to senior detectives of, "You know I killed these lassies," was made under duress, that the fresh evidence, the statements from 5 new witnesses, would definitely have had an impact on the jury's verdict if they'd been heard at the murder trial, as the Crown had actually conceded at the trial that without the double confession there would have been insufficient evidence to convict Andrew Cameron, and that it should be agreed for this evidence to be heard at an appeal by these 5 new witnesses, so the court could satisfy itself that a miscarriage of justice had taken place. As Nicholas Fairbairn revealed at this time, Andrew Cameron had been convicted by a 9-6 majority of killing Kay Wyllie, whereas he'd been found guilty by a 13-2 majority with regards to killing Nancy Nichol. So Nicholas Fairbairn definitely felt the jury could have been swayed in relation to the murder of Kay Wyllie. The Crown's representative, Peter Fraser, said that he believed Mrs. Steed may have been mistaken as to the date and identification of Kay Wyllie. Having considered what Peter Fraser and Nicholas Fairbairn had said, and with Andrew Cameron sat between 2 prison officers holding his breath, the 3 appeal judges agreed with Nicholas Fairbairn's request and ordered that the 5 new witnesses be heard at the Criminal Appeal Court at a date still to be fixed. The Lord Chief Justice General, Lord Emslie, went on to say that the Solicitor General, Peter Fraser, and the Defence Counsel, Nicholas Fairbairn, were to discuss the matter together and present witnesses who they considered relevant to the appeal, with Peter Fraser indicating that he may be calling 6 or 7 police officers to speak at the appeal in connection with Andrew Cameron's confession allegedly being made under duress. This appeal being granted was really significant, as according to an article in the Daily Record on the 14th of April 1986, the only previous successful appeal that had been granted in relation to new evidence being made available had been in 1928 for Oscar Slater, who had been wrongly convicted of murdering Marion Gilchrist in her home in Glasgow in 1908. Another case, in 1969, where Joe Beltrami had also tried to introduce new evidence, was following the conviction of Patrick Meehan for the murder of 72-year-old Rachel Ross, a case we covered and was released on the 7th of September 2021, called Glasgow's Day of Horror, the 1969 shooting rampage. However, this appeal was not successful for Joe Beltrami or Patrick Meehan at the time, although Patrick was pardoned after serving 6 years. Anyway, back to May 1986. The appeal was granted, and everyone thought an appeal date would be fixed for later that same year. However, it wouldn't be until October 1987, nearly 18 months later, that Andrew Cameron's appeal hearing finally took place. This was due to so many rescheduled dates and unforeseen delays, including Nicholas Fairbairn being removed as the defence counsel due to him wanting to instead run in a general election. But when the appeal finally did take place, would Andrew Cameron, Lord Morton, Andrew's new defence counsel, and Joe Beltrami get the outcome they wanted, which was Andrew Cameron's convictions being quashed? In the meantime, back to where we started, and one of the murder victims' families. It was reported that Kay's mum and dad had left Scotland and moved back to their home in Zambia, with Kay's dad saying, "In Africa, I can drive out in the plains and call out Kay's name. It makes me feel better. It's some form of consolation." Kay's mum and dad were due to return back to Scotland for the appeal hearing, which started on the 20th of October 1987. While there were 5 new witnesses supposed to speak at the hearing, and numerous police officers regarding the statements from Andrew Cameron that were allegedly made under duress, all that was reported in newspapers was the evidence given by 3 witnesses, Ruby Steed and her husband Hugh, and a John Penman. I'm not sure if the other witnesses and police officers didn't get a chance to speak, as the evidence given by those 3 witnesses was enough for the appeal judges to make a decision, or whether it just wasn't relevant or interesting enough for reporters to print. Anyway, the first new witness to the stand at the appeal hearing was Ruby Steed from Prestwick, and she was asserting that despite not knowing Kay Wyllie and having never met her before, she was sure she'd seen her driving her white Mini in Prestwick in the vital hours before her death, with a man other than Andrew Cameron who she also didn't know. Here was Ruby's evidence. So Ruby and her husband Hugh, who had been for a night out in Prestwick, said that they left the bar in Prestwick about midnight on the 4th of July 1984, the night Kay Wyllie disappeared, and was last seen about 20 minutes away about the same time in Dundonald. Ruby said that Hugh had romantically picked 5 roses for her from a flower bed just outside the pub, before they had then approached the nearby Prestwick Toll pedestrian crossing, and, while Hugh went ahead and crossed the road, Ruby said she had stood waiting for the green man to show before she crossed. Now I just have to say here that, as a driver, how annoying it is to have to stop at a crossing for someone to cross when there's no other cars in sight, and all the person has to do is wait for my car to pass and then cross behind me. It's so frustrating when that happens. Anyway, it appears that Ruby also did this, as apparently the only car that had to stop at the red lights for her to cross was a white Mini that was heading in the direction of Ayr. Ruby then started to cross the road, and she said she initially thought the driver and passenger in the white Mini were both female, until she started to cross the road. Then she realised that the passenger was actually a man. She then said that this car was an ex-registration Mini, although she only added this at the hearing. She didn't say this in her statement to the police, and that both a female driver and a male passenger were about 18 years old, although again in her original statements to the police she had been unsure if the passenger had been a male or a female, apparently only being sure about this fact at the appeal hearing. Okay, now as a driver who frequently has to stop at crossings for pedestrians, I have to say that I didn't realise any car stopped at lights would be under such scrutiny as Ruby seemed to be giving this white Mini and its occupants. Am I wrong? Do you frequently cross at crossings and take in not only what car has stopped for you, but their car registration number and who is in the car? Maybe Ruby was just super vigilant. I do know, however, that I'm on autopilot a lot of the time, so I do tend to miss things, so it could just be me. Anyway, Ruby went on to say that after Kay's body had been found, she read police appeals in the newspapers and saw a picture of Kay, and so had got in touch with the police to tell them she'd seen Kay in her Mini in the hours before she went missing, but that she never heard from police again, so she assumed her statement was of no use. However, reading about the trial in newspapers, she realised that the statement she had made to police was of value, and so she contacted Andrew Cameron's mum, who in turn put her in touch with Andrew's solicitor, and she gave her statement to them. Apparently, Ruby was not called as a witness at the murder trial, as the times she gave didn't seem to fit. When Ruby was asked by the defence counsel, Lord Morton, if she had any doubts that the girl she saw driving the white Mini was the same girl she had seen a picture of in the newspapers, being that of Kay Wyllie, Ruby replied, "I have no doubts that the girl I saw at the Prestwick Toll pedestrian crossing was Kay Wyllie." Ruby was then asked if anyone in the court that day looked like the passenger in the white Mini. Ruby replied that there wasn't. Andrew Cameron was present at the hearing, sitting between two prison officers. When Ruby was pointedly asked if Andrew Cameron had been the passenger in Kay's car, she said she was positive that he wasn't, as he was too fat, too big at the shoulders. Ruby was then cross-examined by Peter Fraser, who asked her what the exact time had been that she said she had seen this white Mini stopped at the lights, with Ruby saying that while she didn't know the exact time, only being able to say that it was very late, she was absolutely definite that it was Kay Wyllie that had been the driver of the car. In response to Ruby's answer, Peter Fraser said that Ruby had given an astonishingly accurate description of someone she didn't know, to which Ruby replied, "Not really, she was staring straight into my eyes. I got a good look at her. I will never forget that girl. This memory still haunts me." Now, I didn't understand the line of questioning about the exact time Ruby had seen the white Mini as she crossed the crossing, as she had already said her and Hugh had left the pub about midnight, and I can't imagine the crossing being that far away from the pub they left, but if I'm wrong, please let me know. Although this line of questioning did make more sense when Hugh Steed took to the stand, as he said it was nearer 1:10 in the morning that he thought they had seen the white Mini at the crossing, basing this on the fact that their daughter had pointed out the time when they had got home, having walked from the pub. Only 2 tiny paragraphs of Hugh's time on the stand were reported in newspapers, one paragraph being the time difference, and the second with Hugh saying about his wife Ruby, "I warned her not to get involved," and that he had fallen out with Ruby and hadn't spoken to her for days after she had gone to the police initially with information about potentially having seen Kay and her white Mini. And that was it from Hugh. But what the third new witness to take to the stand had to say was widely reported on, as the questioning ended in a dramatic admission. So John Penman told the hearing that he had become involved in the Kay Wyllie case after Andrew Cameron had been convicted, when he had firstly seen a photograph of Andrew Cameron in a newspaper, and then read in another newspaper a story about how Ruby Steed was claiming that she had seen Kay Wyllie the night she disappeared. At that time, he was convinced that Andrew Cameron had been wrongly convicted, as he too had definitely seen Kay Wyllie with a man who was definitely not Andrew Cameron on the night she disappeared in a chip shop called Curly in Crown Street in Ayr, where he and a colleague had been called to repair a fault. He said he was so certain that Andrew Cameron had been wrongly convicted that he contacted a radio reporter and gave an interview, before he then contacted Joe Beltrami and gave him his statement. It was revealed that John Penman was a former police officer. When he was asked by Peter Fraser why he had given a radio interview before contacting the police or Joe Beltrami, he said it had entered his mind and he had done the interview reluctantly and only because he knew the radio reporter and he knew he would treat it in confidence, but that he wasn't an attention seeker and had only reluctantly become involved because he felt it was his duty. It was put to him by Peter Fraser that he had in fact done the interview so as to avoid speaking to the police, which John Penman denied, saying he had no reason to avoid speaking to the police. John was then asked to give the hearing a description of the man he had definitely seen with Kay in the chip shop the night she disappeared, and while it's not reported exactly what description he gave, the length of this man's hair obviously stood out to the Solicitor General, Peter Fraser, as he immediately asked John Penman if he had given a description of the man he had seen in the chip shop with Kay to the police, to which John replied that he didn't recall. And so Peter Fraser went on to tell him that he had given the police a description of this man, and he had said that this man had been well groomed and had short hair. Peter Fraser then asked John if he recalled telling police this in his statement to them, in which John conceded that it was possible that he had said that to the police, but that he didn't recall saying it, which was a bit of an issue, as in the description John had just given at the appeal hearing, he said that the man he had seen at the chip shop with Kay had shoulder-length hair, with the two reports conflicting dramatically. Peter went on to say that this wasn't just a minor inaccuracy, but a serious error, to which John replied that it was. And apparently there was another significant error made in John's statement to the police as opposed to what he was saying at the appeal hearing when he described the man in the chip shop's build. Again, it didn't say exactly what John had said about this man's build, only that there was a significant deviation. At this point, John admitted that his recollection may have been influenced by Ruby Steed's newspaper article, which disclosed the fresh evidence she had put forward. Peter Fraser then asked John if he had called the police on the 10th of July that year to say that he had changed his mind about his identification of Kay Wyllie, to which John replied that he hadn't. But Peter went on to remind him about lying under oath and asked him, "Are you saying you did not make that call?" To which John replied, "If I had made the call, I would remember. I did not make that call." Already feeling the pressure on the stand from the Solicitor General, things were about to really heat up for John Penman when he was asked about the hair colour of the girl he had seen in the chip shop that night, to which John explained that the girl had had dark hair as opposed to brown, and in reply to Peter Fraser asking him if the girl's hair had been light, John replied that it had definitely not been light. Can you guess where this is going? A picture of the body of Kay Wyllie was then shown, and it was the beginning of the end for John Penman. When he saw the picture of Kay, he said, "I'm rather surprised to see that photograph of the unfortunate girl with that colour of hair. The girl I saw that night, from memory, did not have hair as light as that." Upon hearing this, one of the appeal judges asked John, "If the girl in the picture is Kay Wyllie, then you did not see Kay Wyllie. Is that right?" To which John replied, "The hair is too light for the girl I saw." The court was silent at this revelation. This was a huge blow to Andrew Cameron's appeal, but Peter Fraser just had to hammer the point home by asking, "Is there any conclusion that you must now state to the court that you cannot be confident that was Kay Wyllie?" To which John Penman replied, "Having seen that photograph, I cannot now be confident that it was Kay Wyllie. I am satisfied by the photograph that it may not have been Kay Wyllie I saw that night in the chip shop." Shocked and shaken, John then asked if he could sit down and have a glass of water, as, "I have just had quite a shock. I am sorry." As John sat in the witness box, sipping his water with shaking hands, the defence counsel, Joe Beltrami, and Andrew Cameron sat with heavy hearts, realising the hope of an acquittal was slipping through their fingers. There was still Ruby Steed's witness statement, of course, but would that be enough? Now all witnesses had been heard from, although not everyone's appearance on the stand was reported, all that was left to do was for the Solicitor General and the Defence Counsel to sum up. Always with the question in mind, could the jury have been swayed by evidence of Mrs. Steed, given that the murder trial jury had returned a verdict of 9-6 in the case of Andrew Cameron's guilt of Kay Wyllie's murder? Solicitor General Peter Fraser, QC, was the first to sum up, where he accused Ruby Steed of lying and that the evidence she gave was incredible and wholly unreliable. According to an article in the Ayrshire Post, on the 30th of September 1987, Peter Fraser had thought that Ruby had a remarkable facility to improve her recollection of items of evidence as time went by, going on to say, however, that he was not suggesting that Ruby had been drunk on the evening she had apparently seen Kay and her white Mini, but that she had been out drinking that night. It was 1 a.m, it was dark, and yet Ruby was asserting that she had not only had time to study the girl in the car in the short time it took her to walk across the crossing in front of the car, but that she was able to say that the girl's hair had been dark, and she claimed unequivocally that the girl she had seen was Kay Wyllie. This is what Peter Fraser found to be incredible and wholly unreliable. Peter Fraser went on to say that in the statements Ruby Steed had given to the police, she had started by saying that she was almost certain the person she saw had been Kay, but ended the statement by saying that she was 100% positive. Peter Fraser also noted that Ruby had not been able to give an accurate time as to when she had seen this girl and the white Mini, only being able to provide guesses, and that she had attempted to strengthen her evidence by adding extra details at the hearing, such as that the white Mini was an X registration. Peter Fraser stated again that Ruby and her evidence had to be considered highly unreliable. One of the appeal judges put it that if himself and the two other appeal judges were of the opinion that Ruby's evidence was wholly incredible and immaterial, how could they possibly say that a reasonable jury might have taken a different view if Ruby's evidence had been heard at the murder trial? Peter Fraser asked that the judges take the view that Ruby's evidence was not credible or reliable and would have been dismissed by the murder trial jury as such. Peter Fraser ended by saying that should the appeal judges decide to authorise a retrial in the case of Kay Wyllie, then they should not authorise this in the case of Nancy Nichol, as by the verdicts in both cases, the jury had reached a different view of Andrew's guilt in regards to the two cases. Next, it was the defence counsel, Lord Morton's turn to sum up, and according to the same Ayrshire Post article, he argued that at the murder trial he was only required to put a single doubt in the jurors' minds in order for them to return a verdict in Andrew Cameron's favour, and he believed that Ruby Steed's evidence would have done that. One of the appeal judges, Lord Emsley, however, put it to Lord Morton that as the verdict returned for Kay Wyllie's murder was 9-6, and for Nancy Nichol's it was 13-2, the jury must have accepted that Andrew Cameron had confessed to both crimes to police. As if they hadn't accepted this, then there would not have been enough evidence otherwise for them to have convicted Andrew Cameron of Kay Wyllie's murder. But Lord Morton argued that if the evidence by Ruby Steed had been heard at the trial and accepted by the jury as being believable, then the jury may have rejected the evidence of Andrew's allegedly under duress statements. And as the verdict was 9-6, it showed that 6 members of the jury had clearly not accepted Andrew's confessions were not made under duress. Lord Emsley said, though, that a number of things concerned him about Ruby Steed's evidence at the appeal hearing. As if Ruby's statements to police back when she first came forward were accepted, then it showed that, at that time, she didn't mention that the white Mini had been an X registration, and she hadn't been sure if the passenger had been a man or a woman. Lord Morton didn't really address this concern, but instead went on to highlight just how important Ruby Steed's evidence could have been at the murder trial, as it highlighted a very big issue regarding the timings that Kay had supposedly last been seen alive. Kay's boyfriend and his grandmother had given slightly differing times as to when they had last seen Kay, with her boyfriend Russell saying that Kay had left their home at Dundonald about 1 a.m, but his grandmother had said that Kay had left their home between 12:40 and 12:45 a.m, and a third witness saying that they too had seen Kay in the Dundonald area around these times. However, if Ruby Steed had given her evidence at the murder trial, saying that she had seen Kay about 1 a.m. in her white Mini in Prestwick, about a 20-minute drive away from the Dundonald area with an unknown male, then the differences in times Kay had supposedly last been seen could have been picked up and questioned, and the jury may have accepted this evidence, as it definitely raised some obvious questions about who this person was that Kay was seen with in Prestwick, as that person had never come forward. with Lord Morton ending by saying, "The circumstances have a desperate mystery about them." After 4 days' worth of fresh evidence having been heard in a double murder appeal and the closing submissions having been laid out in the Court of Criminal Appeal, the 3 appeal judges adjourned to consider their decision on whether a miscarriage of justice had occurred. 35 minutes later, they were back on the bench. And according to an article in the Ayrshire Post on the 30th of October 1987, they delivered their decision in 138 words. They said, "We have not been persuaded that a miscarriage of justice occurred in this case. We accept that Mrs. Steed honestly believed, as did Mr. Penman honestly believe, when she went to the police in July 1984, that the girl she had seen at the pedestrian crossing was the same shown in the photograph in the Ayrshire Post. We are nevertheless satisfied, however, that her evidence cannot be described as important evidence of quality, because we are unanimous in finding it unreliable. In any event, we are satisfied that her evidence could not have played any material part in the resolution of the conflict of credibility as between police witnesses and Cameron on the critical issue of the confession. For these brief reasons, the appeal will be refused. We shall, of course, issue a complete and full judgment later." Andrew Cameron and his family's hopes of an acquittal and a retrial were crushed. And as he sat pale-faced in the dock between 2 police officers, he was heard to utter the words, "Oh no." Andrew Cameron was heading back to prison to complete at least another 18 years for the murders of Kay Wyllie and Nancy Nichol. Now I'm going to leave this episode there, but there will be a part 4, as there's still a wee bit to tell you. We've still to hear the reactions from Ruby Steed, John Penman and Joe Beltrami after the hearing for starters. And of course, there is still someone we've not heard about yet. Another victim really, if you think about it, and that's Andrew Cameron's mum, who also had her life shattered when her son was arrested and found guilty of 2 murders. A mum who vowed, "I'll always stand by my son." So we'll hear a bit about Andrew's mum's story and her reactions to her son's conviction and his appeal for a retrial being denied, as she said at the time of the appeal hearing verdict that this would not be the end. She would fight on. So we'll hear what her next steps were and what became of her. We'll also hear if Andrew Cameron ever achieved his dream of having his conviction quashed and being granted a retrial. I will try and get part 4 out next Tuesday, but it might end up being released a bit later next week. Hit subscribe now so you don't miss part 4. And until then, I've been your host, Dawn.
Scottish Murders is a production of Clurin Ton.